Good evening and welcome to our Ecclesiastical Law Society lecture. Today, our lecturer Jan Hallebeek brings a lifetime of experience in studying and teaching canon law, especially from the Old Catholic perspective. And most recently, he has been Professor of Legal History at Vrije Universiteit in Amsterdam, which position he retired from 5 years ago. Jan, it's a great pleasure to have you with us this evening. Very much looking forward to hearing what you have to say to us. So over to you.
Thank you. Dear colleagues, first of all, I would like to thank you for the kind invitation to present a paper to your society on the canon law of the Old Catholic Churches. In this paper, I will first address the question of what unites the Old Catholic Churches from the perspective of canon law and whether these laws have a common source. Secondly, I will briefly consider the different ecclesiastical traditions that can be discerned within the Utrecht Union and the principles that underlie the present law. Then I will deal with some aspects of contemporary canon law, such as the sources of law, the administrative structure of the churches, marriage law, the relationship between church and state, and the International Bishops' Conference. And finally, I would like to discuss some issues which I believe will require further attention in the near future, namely the authority of bishops and synods and their mutual relationship, the position of the International Bishops' Conference, and finally the situation of concurrent jurisdictions on the European continent. I turn now to the second paragraph, what unites the churches from the perspective of canon law. The Old Catholic Churches understand themselves even more than being part of the Western Catholic Church as the Christian Church founded at Whitsun. It's true that the churches of the Utrecht Union at some point lost communion with the Bishop of Rome, but it's also true that they neither sought nor wanted such a break. There are different reasons for this drifting apart, and so we should distinguish between different churches. I will come to this in a moment. But the basic attitude just mentioned implies that the Old Catholic Churches derive their identity only from the Western Catholic Church. Hence, their theology and liturgy are essentially Catholic. Does this also apply to canon law? Can we say that the canon law and the constitutions of the churches of the Utrecht Union, as they developed at the time of the establishment of the churches, are also interrelated because they have their common roots in the tradition of Catholic canon law, as handed down in the various parts of the Corpus Juris Canonici? This is a question of continuity and discontinuity to be answered separately for each church. Once this is clear, it will be necessary to see whether, since the emergence of the Utrecht Union, new conditions have arisen which require a common understanding of canon law and they are therefore decisive for a common identity. To answer the question of continuity, we need to know what the tradition of Western canon law is. But this is problematic, especially with regard to the relationship between the local church and the universal church. Up to the 19th century, the sources of canon law contained elements that dated back to the early church and emphasized a certain autonomy of the local church and ways of collegial decision-making processes in provincial synods, as well as elements that came from the Gregorian church reform. The latter promoted a centralized structure of the church and played a dominant role in the late Middle Ages, while the Pope and the Ecumenical Council alternated as a universal center of power. At the Council of Trento, the Gregorian model seemed to prevail, but some of the old rules, which still respected the local church's right to self-determination, were not abolished. This ambiguity in the traditional sources of canon law came to an end at the First Vatican Council, with the dogma of the universal jurisdiction of the Pope and its elaboration in the Codex Juris Canonici of 1917. It was not until the Second Vatican Council that the local church was restored to a full position, however, without revisiting the above-mentioned dogma. By that time, the traditions of Old Catholic canon law had been established for a long time. In order to answer the question of continuity or discontinuity, we should look at the historical circumstances of the formation of the churches, especially those which came into being in the years following the First Vatican Council, and also be aware of the kind of canon law with which continuity might have been achieved, namely that which was in force or older traditions of canon law. I turn now to the third, maybe you can show the slide again, the third paragraph, diverse canon law traditions. And I will deal with three topics: Church of Utrecht, German-speaking countries, and the Polish churches. Although the immediate causes of the break between the old Catholic churches and the Bishop of Rome varied, the same basic attitude was decisive in all cases: resistance to the unconditional submission of the local church to a universal center of power. We will now take a closer look at the various processes of church formation and the development of an own ecclesiastical law. In doing so, we can further examine whether there is a connection with the canon law in force at the time or with older traditions, and whether we can speak of common principles of canon law. In the 17th and 18th centuries, a certain alienation developed between two groups of Catholics in the Dutch Republic. Three factors played a part of this. From the point of view of canon law, the most important was the dispute as to whether the pre-Reformation Catholic Church and its institutions still existed, or whether the Church had perished so that the Dutch Republic had become a mission territory. There was good reason to believe that the Church was still in existence. Even though the Protestants had deprived the Catholics of their churches and monasteries, the public practice of Catholic worship was forbidden, and the Catholics were second-class citizens. On the other hand, the chapters of Haarlem and Utrecht still existed, although the latter had been reorganized. The parishes had found new places of worship in hidden churches, and a vicar apostolic had taken over much of the role of the diocesan bishops. In 1704, Vicar Apostolic Petrus Kodde was deposed by the Pope after being accused of Jansenism. The Church in the Republic was thus deprived of a bishop who could perform ordinations, consecrate chrism, or administer confirmation. In 1723, the chapter of Utrecht decided to put an end to this undesirable situation by electing a bishop and having the elect consecrated. The Pope refused to confirm the election and broke off communion with this bishop and all the clergy who recognized him as their diocesan bishop. However, the action of this chapter in this situation was fully justified by eminent theologians and canonists on the basis of the sources of law and in force at the time. The emergence of an Old Catholic Church in the Netherlands, as it was later called, is therefore closely linked to the defense of the local church's own competences and responsibilities. As in the Netherlands, the emergence of Old Catholic churches in German-speaking countries had to do with the assertion of the position of the local church. However, the circumstances were quite different from those in the Dutch Republic in the 18th century. Rome did not break communion with the church province, but with a movement of Catholic theologians and other believers, especially lay people, who opposed the new dogmas of the First Vatican Council. The protest was not against the infringement of the rights of a particular local church, but against the elevation of the universal jurisdiction of the Pope to a dogma that left little room for the local church's own responsibility. The attitude towards canon law was therefore different from that in the Dutch Republic. The Dutch invoked canon law to defend the position of the local church. The Germans did not invoke the law, but protested against the implications of the dogma for canon law as it was eventually codified in the Codex Juris Canonici of 1917. The attitude to the primitive church was also different. For the Dutch, it was a framework or a basis for interpreting canon law. For the Germans, it seemed to be a guide for developing new structures. Another difference was the Germans' susceptibility to new social achievements and the secular principles of the rule of law. As the Old Catholic movement in Germany moved towards the establishment of a church, it soon developed a constitution and introduced an innovative administrative structure in which, alongside the diocesan bishop, there was a synod composed of representatives of the clergy and the laity with considerable powers. The justification was sought in the Council of Jerusalem, described in the book of Acts, where all those present participated in the decision-making process, and in the conviction that the Holy Spirit is given to all. The Synod is the mouth of the Church through which God's Spirit speaks. A similar episcopal synodal structure was adopted by Old Catholics in Austria, Switzerland, and Czechoslovakia. The Swiss constitution has also been influenced by secular constitutional law and can be considered even more democratic. After the Union of Old Catholic Churches in 1889 was established, a number of other churches joined them. These were not born out of a defense of the local church, but out of an attempt to preserve a cultural or ethnic identity. The American Polish National Catholic Church was a member of the Utrecht Union from 1907 to 2006, almost 100 years. This church grew out of three groups of Polish parishes that had lost communion with Rome. The church was founded in 1904 when the first synod was held. The Old Catholic Church of the Mariavids in Poland emerged from a reform movement within the Roman Catholic Church. It belonged to the Union of Utrecht from 1909 to 1924. And the missionary diocese was also established in Poland, namely by the American PNCC. It adopted the synodal structure of its mother church and became independent in 1951. This Polish Catholic Church is still a member of the Utrecht Union. I turn now to paragraph 4. Maybe you can show the slide again. Yeah, that 4. The common principles of canon law. And you can see that has 4 topics. We have seen that when most of the Old Catholic churches were in the stage of being established and soon to be united, there were different approaches to canon law and the tradition of the church. The Church of Utrecht adhered to the old law of the Corpus Juris Canonici. It didn't feel bound by recent developments within the Roman Catholic Church, especially since the Pope was considered to have deviated from the straight and narrow after the proclamation of the dogma of the Immaculate Conception, 1854. The Roman Catholic Church was considered not to hold any longer the full truth. And the churches in Germany and Switzerland felt less bound by pre-Vatican law and soon adopted an innovative administrative model. It contained elements inspired by the primitive church, but not part of the traditional canon law. In various churches, there was a critical attitude towards the idea of law in the church. The Dutch Old Catholics had invoked canon law in the past to defend the existence of the local church, but they had resisted juridification of church life, especially the Jesuit idea of moral theology as a kind of legal order. In Germany, canon law was increasingly seen as a means of extending and confirming a centralized church structure. In Germany and also in the Netherlands, the idea, defended by the Leipzig professor Rudolf Zohm, that something like law simply did not belong in the church may also have played a role. In the course of the 20th century, this skepticism was largely overcome. The prominent Old Catholic theologian Kurt Stalder published an article in 1982 in which he argued that there was no antithesis between church and law. He defended a full place for canon law, but not a canon law that oppresses or punishes, but a canon law that enables us to give account of the responsibilities entrusted to us within the church. All Old Catholic churches now have a partial codification, which mainly sets out the administrative structure of the church. In most cases, there is also a concise regulation of the disciplinary law for clerics, including rules of procedure. What is lacking are detailed rules for the administration of the sacraments. In spite of the risk of inequality, it has been preferred to solve pastoral problems in a pastoral rather than in a legal way. A common basis for canon law can be found in the 1889 Declaration of the Old Catholic Bishops. It says that the dogmas of the First Vatican Council, which nullify, zerstören in German, the constitution, die Verfassung in German, of the early church are to be rejected. Obviously, the focus was on the early church and its constitution was adopted as normative. The declaration didn't make clear what this constitution was. From other sources, we can form an idea of what the bishops and theologians had in mind. namely elements of canon law that we can still discern today. The local church, not unconditionally subordinate to a universal center of administration, the diocese as a central unit, the bishop and clergy forming a college, the faithful gathered together in congregations, and so on. A third common principle is the episcopal synodal structure. The Church of Switzerland followed the German Church in 1875 by introducing a synod. The Church of Austria did likewise in 1879. The Polish National Catholic Church in the United States established a synod in 1904 before joining the Utrecht Union. And when the Czech Church became independent in 1918, it retained the Austrian institutions while the Austrian Church re-established itself. In the Netherlands, a synod for the Church province was introduced in 1919. And the Polish Catholic Church, initially a missionary diocese of the PNCC, had a synod from 1928. It retained its administrative institutions when it became an established church in 1951. A fourth concept for a common basis of canon law within the Utrecht Union is the ecclesiology of the local church, or rather, the Old Catholic version of such an ecclesiology. It was primarily Swiss theologians, such as the aforementioned Kurt Stalder, followed by Herwig Aldenhoven and Urs von Arx, who developed this theology. In the course of time, it became the mainstream ecclesiology within Old Catholic theological thought. In short, it holds then that when salvation in Christ becomes a reality for a local community, that community is fully church. Thus, the church is a local community which celebrates the Eucharist with its bishop and is linked through its bishop to other local churches. And the materials of this ecclesiology, scripture, creed, Eucharist, bishop, are rooted in the early church. I turn now to the fifth paragraph, the present situation. Maybe you can show the slide again. Yes, so I will now discuss the present situation. You can see sources of law, administrative structures, matrimonial law, relationship between church and state, and the legal nature of the International Bishops' Conference. So the next question is what understanding we can gain from a global analysis of the present situation. So I will look at legal sources, administrative structures, the German and Dutch matrimonial law, the relationship between church and state, although that is not really a matter of canon law, but somehow related. And finally, the nature of the International Bishops' Conference, which is problematic, I think. As the main source of law, all the Old Catholic churches united in the Utrecht Union have a partial codification of canon law in a concise or less concise basic document called Constitution, Statute, or Regulation. This basic document is supplemented by additional directives, regulations, bylaws, etc. The main documents concern the administrative structure of the church, its offices, bodies, and their responsibilities and power. In most cases, there are, as I said, additional regulations with disciplinary rules and a concise code of procedure, but there are few specific provisions on the administration of the sacraments. The innovations of 2000 in the decision-making process of the International Bishops' Conference are only elaborated in some documents. We call that centripetal provisions. The statute of the conference stipulates that the local church has a special role to play in the preparatory phase of important decisions of the conference, as well as in the process of receiving and implementing these decisions. But these rules are not yet elaborated in most of the constitutions of the various churches. Most churches have introduced a synod, following the example of the German church. This explains why we find similar institutions and similar bodies, but with all kinds of differences. At the highest level, there are usually three organs or bodies: the bishop, the synod, and a committee of synod representatives. However, the division of responsibilities between these bodies varies from church to church. In many churches, the synod has the final say on matters of administration and finance, while the bishop has the final say on matters of doctrine and discipline. Only in Switzerland does the Synod have a final say in matters of faith, although a special procedure must be followed. In most cases, the bishop is elected by the Synod and can be deposed by the Synod after a special procedure with strict requirements. The Dutch Synod differs in many ways from that of the other churches. It's mainly advisory. The bishop do not have a seat in the Synod, and the Synod does not elect or depose a bishop. In the Netherlands, the elections are still made by either the chapter or the clergy of the diocese. Now, a few words on matrimonial law. Well, since the 19th century, the Dutch Church does not consider marriage itself to be a sacrament, but rather the ecclesiastical blessing of a marriage contracted before the secular authorities. And consequently, there is no need to annul marriages, as is the case in the Roman Catholic Church. The civil authorities are competent to solemnize marriages and also to dissolve them. However, Christian spouses are not allowed to divorce, which means that in case of a divorce, it's impossible to administer the blessing of a marriage for a second time. Only since 1992 has the parish priest been able to apply to the bishop for a dispensation, which is granted only under certain strict conditions. In Germany, it's more easy. Secular divorce is recognized by the church as the end of the marriage, and for a new religious marriage, the priest must only be satisfied that there is no impediment of an existing marriage. So the first marriage must be definitely come to an end. Now a few words on the relation between church and state. Actually, not canon law itself, but nevertheless related to the topic of canon law. Since the 19th century, the relationship between the churches and the civil authorities in the German-speaking countries have been governed by secular public law, something we do not know in the Netherlands. When an old Catholic church is recognized by the state, it becomes a body corporate under public law, as do its institutions such as dioceses, deaneries, parishes, schools, foundations, etc. This gives the church the power to appoint parish priests under public law. The provisions of secular public law which apply to those churches recognized by the state are called Staatskirchenrecht, state church law. In Germany, Switzerland, Austria, and Poland, there are specific secular laws applicable to the old Catholic churches. In Germany, they vary from land to land, in Switzerland from canton to canton. In the Netherlands, we have a totally different situation. There is no specific legislation for separate churches, and only a few legal provisions are applicable to religious communities in general. For example, the Dutch Civil Code provides that churches and their independent parts have legal personality without any specific conditions. Moreover, rules that apply to all social associations apply also to churches. This means, and that is a difference with France, that churches and religiosity are not excluded from the public domain, as is the case with the French laïcité. And this is why we speak in the Netherlands about inclusive neutrality. Now, the legal nature of the International Bishops' Conference. Yeah, the comparison shows that old Catholic bishops have different discretionary powers in the limits of their particular canon law and within the limits of secular legislation. At the same time, they have a responsibility to maintain unity within the Utrecht Union. In the Bishop Declaration of 1889, the bishops were united in their rejection of the dogmas of the First Vatican Council. But over the course of more than a century, the Union reached agreement on many theological insights. The Union was more or less forced to do so by ecumenical dialogue, especially with the Orthodox churches. It is clear that the International Bishops' Conference has struggled to steer a common course without degenerating into a universal central power. I will return to this in my final part of the paper. Number 5, maybe you can show the slide again. What I call outlook, and I will deal with 3. I can't see on my screen the third topic, but it's Bishop and Synod, the position of the International Bishops' Conference, and the final topic is the occurrence of of overlapping jurisdictions. What are the challenges facing canon law today? I will mention three. One is a problem to be solved in each local church. The second arises at the international level, and the third arises from the external relations of the Utrecht Union. I start with bishop and synod. The administrative structure of many old Catholic churches hasn't changed since they were established at the end of the 19th century. The structure is characterized by a synod as a representative body of clergy and laity with wide powers. These synods were introduced at a time a wave of democratization was sweeping across continental Europe. The Old Catholic movement was open to the achievement of the constitutional state, which would soon recognize the right to vote as a fundamental right. The participation of lay people in a synod was inspired by the Apostolic Council of Acts 15, the idea that the Holy Spirit speaks to all, but also by the desire of many lay Catholics in Germany to have a voice in the governance of the church. The new canon law was inspired by the early church, but was not in keeping with the spirit of, but was also in keeping with the spirit of the times. In retrospect, it has been regretted that these innovations were seen by many as an attempt to democratize the church in an anti-hierarchical way, that the nature of the synod was too strongly modeled on parliamentary democracy, and that the church failed to find appropriate forms for the more important extra-synodal, but still synodal context between bishop and priests, and between clergy and laity. As noted previously, Old Catholic theologians developed a distinctive ecclesiology of the local church, which became mainstream doctrine and found its way into the preambles of various documents of canon law. However, this theological reception did not lead to changes in the actual norms of canon law. This step has yet to be taken. And as a matter of fact, an ecclesiology can't be translated into concrete juridical prescriptions, but it can certainly point to certain prerequisites and help to find a balance between episcopal and synodal competences. According to the ecclesiology of the local church, episcopal and synodal elements are interwoven, and episcopal leadership and communio are not mutually exclusive. It would be the task of canon law to find a way out in the unhoped for case that the exemplary model of dialogue ceases to function. The process of developing such a solution, whether through procedural or substantive rules, should not be determined, in my opinion, by modern democratic constitutional law, but rather be inspired by the constitution of the early church and the episcopal and synodal elements of the ecclesiology of the local church. As I said, the position of the International Bishops' Conference is somewhat problematic. On the one hand, the idea of a universal center of power has been rejected. On the other hand, Catholic churches are linked across borders. In the attempts to make the position of the International Bishops' Conference more precise, we see a movement over the last 50 years. At times, the conference has sought to maintain unity by giving itself rather strong authority to bind the bishops and their churches to a common direction or a majority position. The agreement, Vereinbarung, of 1974 gave the conference its own jurisdiction. In the ensuing period, there have been attempts to control episcopal elections or to make them subject to approval of the conference. In recent decades, this attitude has changed. The 2000 chapter of the Statute of the Conference recognizes that bishops are bound by the particular law of their churches, and that only after a process of reception can the decrees of the conference become effective in the local churches. The question then arises as to the legal nature of the conference, given that it has no jurisdiction of its own and no binding doctrinal authority. We should probably say, but now I am anticipating the outcome of discussion, which has not yet reached an end, that the International Bishops' Conference is the place for fraternal consultation with the intention to act as harmoniously as possible, and that the conference also has, of course, a moral authority. My final point, the concurrent jurisdictions. Yes, this has to do with the external relations of the churches of the Utrecht Union. On the continent of Europe, there are Anglican and Episcopalian dioceses in the same geographical areas of Old Catholic dioceses. This is in no way, we should always realize, as contrary to the Bonn Agreement of 1931, where Old Catholics and Anglicans agreed to establish intercommunion, later called full communion, between their churches. The agreement was based on the principle that each church accepted the other as an independent jurisdiction with its own doctrinal views. Nevertheless, from the Old Catholic perspective, the situation was often perceived as undesirable. As far as I know, the question of how to deal with concurrent jurisdictions has been debated twice also. It has been debated between the bishops many times, but also twice by Anglican and Old Catholic lawyers and canonists. The first such conference took place in Amersfoort in October 1947, when a delegation from the Church of England's Council on Foreign Relations met with the Dutch Episcopal Commission for Canon Law. The Old Catholics wanted to see if Anglican chaplaincies and Old Catholic parishes could be brought together under the same jurisdiction, but there was no general support for such plans. The conference merely confirmed the existence of concurrent jurisdictions and gave some practical advice on pastoral cooperation. The second talk took place in Amsterdam in December 2007 with only 4 participants, 2 Anglicans and 2 Old Catholics. They had to consider a proposal put forward at a meeting of Old Catholic and Anglican bishops in Madrid in 2006, namely that a suffragan of the Bishop of Gibraltar should be appointed to a vacant episcopal see in the Netherlands, who would then look after the Anglican chaplaincies. The idea raised many questions of canon law, both theoretical and practical. However, given the differences between Old Catholics and Anglicans at the time, which were by some Anglicans perceived to be profound, there was reluctance to consider any form of more formal cooperation between the churches. Nevertheless, and this is my final comment, I would like to express the hope that the issue of concurrent jurisdictions will return to the agenda, not only of the Anglican Old Catholic International Coordinating Council, but also that of us canon lawyers. I agree that the development of more formal forms of cooperation and integration goes a step further than the Bonn Agreement. However, the existence of concurrent jurisdiction doesn't fit well with our ecclesiological conviction that the Church is a local community celebrating the Eucharist with its bishop. From this perspective, 2 bishops in the same place looks like an anomaly. In 1998, the Lambeth Conference adopted a resolution which stated, and I quote, "This conference, noting with appreciation the progress made so far by the parallel Anglican jurisdictions in continental Europe, working both with each other and with churches in communion in the area, resolves to encourage continued exploration towards appropriate provincial structures for Anglican continental Europe in partnership with other churches in the service of the common mission of the Church." End of quotation and also end of my paper. I thank you very much for your attention. And I see that the mic that you didn't see my face, but now it's fixed again.
Jan, thank you so much for that tour de force, taking us through the history, the canon law of the old Catholic churches. And yeah, it was just at the last moment you knocked your screen, so that didn't affect most of the most of the talk. But that was so fascinating. I don't know about the other people here in the meeting or those watching the recording later on, but I suppose most of my speaking personally, my exposure to the Old Catholic Church has been historically the 19th century context. So hearing a little bit about the more recent developments, especially from the canonical perspective, has been fascinating. And as an Anglican, that so many resonances in what you said. Obviously, a lot of familiar terms such as bishops and synods, but some of the questions that you pinpointed as the particular matters that have been discussed and held in tension seem to me have been very, very similar ones for Anglicans so often. different streams in the church discussing whether canon law is there to oppress or to enable. You know, the very words I use in teaching canon law. Some of the issues over marriage, over in the Church of England, certainly that the synods being modelled in many respects on Parliament. But I'm going to begin with a question, if I may, before I open up to others. And I'm particularly drawn to this because you mentioned that sacramental law is not a huge area of Old Catholic canon law, that there are not so many provisions. And the reason I fix on that is because on Saturday we had our Ecclesiastical Law Society annual day conference, and we were looking at liturgical law of the Church of England. The question was dead or alive. And although there is a quite significant amount of liturgical law in the Church of England, as we were discussing on Saturday, there is very little enforcement of it, very little liturgical discipline in practice. And we explored how this arises for historical reasons, that clergy were even imprisoned in the 19th century for liturgical infractions. And then there was a diversity, perhaps is increasingly seen as a good thing, of people pushing against the boundaries of liturgical law in the contemporary context. So I was wondering, really, just it would be interesting to hear more from the Old Catholic context. Are there those who think there should be more sacramental and liturgical law? Is there any discipline if what happens if clergy are seen to push the liturgical and sacramental practices beyond what's acceptable? How is it handled? How is it perceived?
Yeah, thank you for your question. Yeah, what I meant to say is that there are very little legal provisions on administering the sacraments. But at the same time, all the churches have books which are officially promulgated or officially introduced by the bishops, and those books are full of rubrics. So, for example, the Dutch Church has a missal, has a hymnal, has a prayer book, and so you're not entirely free to do whatever you want. And in practice, of course, there are parishes which have a more experimental liturgy than others, who are very close, stay very close to the book. But the fact that there is no legislation, not very much in the Constitution, and not very many bylaws, does not mean that there is no liturgical law at all. There is indeed liturgical law, and I think that is also good because when you're a small church, people must feel at home if they worship in another parish, and not to have the feeling, well, where am I now? You know what I mean? Yeah. So I think that the variety within the Anglican Church is much broader, from the evangelical side to high church. It is a much broader field, much more distance than in. If you compare with Germany, Germany is, we sometimes do not feel at home in German Old Catholic churches, because we are more high church, and we miss then the incense and the service and things like that. So that's a little bit,
Thank you. No, that's really interesting. But before I ask you to ask your question, Olga's put a hand up. If anyone else has questions following on from Olga's, please do find in the Zoom buttons, and it's probably under reactions, raise hand, or I see Alan's just said something in the chat. Do also, if you prefer, write a question in the chat, and then I'll read the question out. So Olga, would you like to ask your question? And hello.
Thank you. Yes. Good evening, and thank you very much, Professor. A topic you didn't touch on, and I think you may say that this isn't canon law, but clearly it is part of the legal context in which any church exists, is the question of property. Now, I'm particularly familiar, as I think is Russell, with the 19th century context, especially in the German-speaking countries, where Old Catholics emerged at a time when there were major differences between the temporal powers in some Protestant territories of Germany and Switzerland and the Roman Catholic hierarchy. And therefore, there was a tendency, a willingness on the part of temporal authorities to treat the Old Catholics as the true successors to the older Catholic institutions, and even perhaps to move towards handing over control of some property to the Old Catholics. I'm interested to know how far that ever became a permanent arrangement and what legacy that has left today in terms of Old Catholic ownership of assets.
Mm-hmm. Well, this is this topic which also varies from church to church, from country to country, and it's difficult to give an answer which holds good for all the churches. Yeah, well, I think you have said already something about Germany. That has been in many places. It has been enormous struggle. Who was entitled to the old church building, for example? Huh? The Old Catholics who claimed to be the continuity of the old parish, and but in general, it's difficult to say. I can say what happened in the Netherlands, that in the time that the Protestants the Protestant church was the established church, Catholic parishes were not allowed to have, could not have property. So always through intermediaries, churches were owned, hidden churches in that time, and only at the end of the 18th century, then it was possible to it was also accepted that churches could own their own churches, also that they could inherit, for example, which is also a problem in the old days, that you could not legate anything to a church. Also, always an intermediary who would give it to the church. But that is all I can say about it. In Germany, the history of each local community is different, and also depends in Germany on the Staatskirchenrecht. As soon as the church is recognized, but the Old Catholics were not recognized in every part of Germany at the same time. And if I'm well informed, there is even one of the Ländern where nowadays still the Old Catholics are not recognized by the state. But as soon that is, they have rights, and they should be treated in an equal way. So I know from some local histories, that the group of Old Catholics was so considerable that they were able to claim to be the continuity of the old parish.
Thank you.
Well, we have a question written in the chat from Alan, who can't open his microphone, so I'll read it out. He says, there was a brief mention of the Mariovites. Could I ask about their present status? Some of their doctrines must have challenged Old Catholic orthodoxy.
Yes. Yeah, the Mariovites, that was a short period, actually, that they were member of the Utrecht Union. It ended about, what did they say, 1924. Then very strange things were happening within the, if you may have read the book, The Third Adam, which describes this fully. And so there was no other solution for the Old Catholic bishops than to say, well, we stop our relationship. And in the meantime, things have changed, and there were already talks, let's say about 15 years ago, about the Mariavites returning to the Utrecht Union. But yeah, well, that is difficult at the moment because then nowadays we would like a new church for entering the Utrecht Union also to have a kind of synod, a kind of structure, and the Mariavites were always organized like the third order of the Franciscans. So they had a chapter ruling the church, and there are no representatives of parishes or things like that. And so the Utrecht Union said, well, can you try to reorganize yourself a little bit more like the other churches? And well, I really don't know whether this happened or not, or whether they don't would like to do this or not. But anyhow, until today, they are still no part of the Utrecht Union. But there are contacts, and for example, the students of our seminary, they will visit in September Poland, and of course, they will visit the Poland National Catholic Church, which is a member of the Utrecht Union. But I'm sure that they also shall go to Plock. I'm difficult to say the center of the Mariavites, because there are still friendly relations. But I can, if you are interested, I can advise you to read the book, The Third Adam. I don't know the name of the author, but it's all about the Mariavites and how they came into existence, and how, yeah, well, until, let's say, the Second World War, that period is described in the book. Oh, you know the book, so
Yes,
nothing to explain.
Alan mentions yesterday knows the book in the chat, but I don't. It certainly sounds intriguing, if possibly a little, well, unusual. I wonder if anyone else has a question. If you're struggling finding the hands up button, feel free just to unmute and ask a question. Well, I have another question, and I was just reflecting on the similarities, Jan, between what you described between the International Bishops' Conference and the questions over their jurisdiction, and the Anglican Communion. As you know, there have been many debates about the authority of the instruments that Anglicans have at an international level, for example, the Lambeth Conference. And basically these instruments, as a rough approximation, one can say, do not have any authority over the member churches of the Anglican Communion, but canonically speaking, but perhaps they have a moral and persuasive authority. And so there are these tensions when different provinces start to move in different directions, especially over ethical matters. Then this has ramifications on intercommunion between Anglicans, but there are certainly no canonical processes really to resolve them. And I was wondering really whether you see any parallels between the International Bishops' Conference you've described and that search for what is their jurisdiction, what is the role of the conference, and the Anglican experience. Do you see any points of comparison where we can learn from one another and that sort of thing?
Yes, there are absolutely similarities, but that holds good for all Episcopal churches who do not recognize universal subordination to a universal center of power, and that is, we must admit, of course, that's much easier if you say let the Pope decide. That you have the problem. You do not have the problems we have. It's much more difficult to say no. We do not recognize that, and we are going to a complicated decision-making process, and we are going to try to find consent about certain issues, and that can take many years. And well, we have this experience with the ordination of women, of course, that was a process of decision-making of 30, 40 years. And then even there was a point that the Polish National Catholic Church could not accept, well, they were free, of course, not to ordain women, but they could not accept that the others would decide to do that. And so that was a break point. And so they left the Utrecht Union. And that was, of course, very sad, because the church has been a member for almost 100 years. And so that is, that is, but that is the price you sometimes have to pay. And on the other hand, you can't ask from the other churches not to ordain women, because at a certain point, well, there is so much, support to do this within the churches, and so much resistance against not doing it, that it is that is not neither a solution. And the problem is, well, the relation with the Anglicans, there was the problem with to establish full communion with the Orthodox churches. There were sufficient consensus text. The entire dialogue was finished, but then the Orthodox said, well, yeah, but you are in full communion with the Anglicans. We don't want to have full communion with you. So so it's always difficult, yeah. But I agree with you. The situation now since 2000 is that if there are difficult decisions to be taken on an international level, that the preparatory work is done in the local churches. So the local churches will discuss the questions. Then it goes to the International Bishops' Conference, who can decide by majority, but after that, the decision has to be implemented, received. And that means, again, that the synods of the local churches are going to discuss it, and a bishop can't promulgate something if his entire synod is against it. I mean, apart from the legal aspect, so we make it ourselves very difficult, yeah. And that we have in common, Anglicans and Old Catholics. Yeah.
You. Now we probably have time for a final question, if.
Now, if that is a possibility,
Hmm.
I'm Jan de Bij, and that lovely name of Ilonka is my wife's name, whose laptop I'm borrowing, actually. I must confess that Professor Hallebeek and I meet more or less regularly on a platform of cooperating mainstream churches in the Netherlands. And interestingly, Jan, I may say Jan to Professor Hallebeek, interestingly, we touched on the subject of having an Anglican bishop filling a vacancy, or in fact being nominated to a vacant diocese in the Netherlands, be it for a somewhat different reason than just the parallel jurisdictions on the continent. It was more to do with, well, how shall we say it, the more or less drying up of Christian culture certainly in the Netherlands, where we see church closures and depletion of numbers. But I was glad to hear that this old hobby horse of mine has been picked up finally by the powers that be. And so, Jan, could you tell us a little about this? What was the idea? What would be the relationship between that particular bishop, who would have a suffragan role?
Yeah, it's difficult
the ordinary of the diocese in Europe and all that.
Yeah. Well,
come on, tell us something.
This idea emerged at the conference between Old Catholic and
You're
Anglican.
frozen.
Okay. Yeah, but can you hear me?
Yes. Yep. We can.
Okay. I answer anyway. I mean, the idea emerged at a conference between Anglican and Old Catholic bishops in Madrid, in Spain, in 2006. What was the case? The Old Catholic Church of the Netherlands usually had 3 bishops. An Archbishop of Utrecht, a Bishop of Haarlem, and a Bishop of Deventer. And the See of Deventer was vacant. And the church was also getting smaller and smaller, so there was no necessity to elect a new bishop for the See of Deventer. And the idea that they had in Madrid was that why not make a suffragan bishop of the Bishop of Gibraltar at the same time diocesan Bishop of Deventer, and then he could let's say be part of the Dutch episcopacy, and at the same time he would have under his jurisdiction all the Anglican chaplaincies in the country. Well, if you think through this, you come to all kinds of difficulties and objections, and but I must say that this meeting, I was one of 2 old Catholics who were there. Didn't come to further elaborate the point, because from the Anglican side there was no real cooperation, and but I think the times have changed, may have changed. What difficult issue was then same-sex relations, divorced people in the church, and the Old Catholics were quite liberal about that, and I think the Anglicans had a more stricter attitude or more stricter approach to things like that. But that is, we speak about almost 20 years ago, so I really don't know what the situation now is.
Since then, we've gone through living in love and faith and all that. Yes.
Yeah, and even if you have a difference in opinion on those issues, that doesn't have to be an obstacle to come to a more formal cooperation. But I must, of course, admit, as I said, that it goes really a step further than what is said in the Bonn Agreement. And yeah.
Thank you. Wonderful. Thank you so much. We've filled the time of the allotted to the questions and covered a lot more ground. So thank you, Jan, for staying on to take us through that discussion. It's been a fantastic evening. I've certainly learned a huge amount about the canon law, the history, the present situation of the Old Catholic Church. And I reflect that, as so often when we discuss canon law and matters move into ecumenism, and we grow in understanding of our Christian brothers and sisters, and see so many of our own issues reflected in what's going on in other communions, and that's always encouraging and a good way of learning. So thank you so much for all the time you've taken, Jan, preparing for this evening, delivering your lecture and talking to us. Very much appreciated.
Thank you very much. And well, I hope we keep in contact and in the near future. Yes.
Absolutely. Look forward to that.
Okay. Bye-bye.
Good night to all. Goodbye.
Bye all.
Good night.